Hi, I'm Heather O'Connor from O'Connor Family Law. In another video, we talked about what exactly is a motion for temporary orders. In this video, we're going to talk about what to expect when you go in for the hearing. So you'll get your date, and you and your ex will have to show up to court. Prior to going in front of the judge, typically you will have to go to probation. Now, it can be called family services. A lot of people call it probation. It's very different than probation in criminal court. It is not a probation where they're regulating you or they're following you or you have to pay money. It's more so if you think of it as a mediation type of service. You'll go in, you'll sit down with a family service officer or a probation officer, and they're going to listen to both of you and see if there's any areas where you can come to an agreement. If you're able to come to an agreement on even one of the issues, the probation officer, and if you have two attorneys, they'll be doing it, but they write up what's called a stipulation, and that will be presented to the court, and that will become part of your temporary order. Now, if you can resolve all your issues, that's fantastic, because walking in front of a judge, there's always some sort of risk that you're not going to get what you're looking for. And often, not always, but often, it's better if you're able to control the outcome than just throwing it in front of a judge who is a complete stranger to you that knows nothing about you except for maybe, if you're lucky, the 15 to 20 minutes that you or your attorney is going to be able to present your case. Now, I've seen hearings where a judge will not even give that much time. And if you're coming out of a marriage that has any significant length to it, it's very difficult to compact all the issues that's important for the judge to hear down into 5 to 10 minutes. So that's why it's always better to take that mediation process very seriously and see if there's any issues that you can come to an agreement on. Now, there are some times that you're not going to be able to come to an agreement, and that's okay. Judges do expect it, although they do like when people are able to settle. But if it's a situation where you honestly believe your children are in danger, you honestly think the other person is either just being a bully or not agreeing, and you have a good legal basis, then it might be an issue that you want to take in front of the judge. When you go in front of the judge, what I see a lot of times is that the other side just starts slinging mud, and they talk about all these things that to you are emotionally very important. And you want to justify the fact that that's not true. And you want to come back and argue about every single thing that they've said that they're lying. But it's often not the right way to present your argument. There's certain things that a judge needs to hear in order to give you what you're looking for. And if you get very hung up on the fact that the other side is just throwing that mud and making you look bad, and you want to retort every single thing, you might not get to the issues that the judge needs to hear. And then you might not get your way just because you weren't able to get your argument across. And that's why it's very important to be prepared. Now, along with that, do you need an attorney to represent you on a motion for temporary orders? Technically, no. You can go to court at any point in time and argue for yourself, and it's what we refer to as pro se litigation. The problem with it is it's very hard, and I've been through my own divorce, so I understand this. It's very hard to separate your emotions from almost the business of law and the part that you have to get across to the judge. So if you can't stay very focused and you can't be completely educated on what needs to be presented to the court, it's probably much better if you have an attorney. I always recommend you have an attorney just because we know how to deal with these issues and can be a support to you and make sure that the argument's getting across correctly. But at the end of the day, that's your choice. So part of this video is to help educate you if you are going out on your own. So at the end of the hearing, the plaintiff, so the person who filed the motion first, will be the person who gets to argue to the court first. That person will get to go. You do not want to talk if you are the other person while that person is speaking. There is no better way to piss off a judge than to start interrupting the other side or interrupting the judge if they're talking. So definitely do not do that. So once the plaintiff, so the first person who files, finishes their argument, then it will move on to the defendant, the person who is responding to the motion. And you will have your chance, if you are the defendant, you'll have your chance to come out and still say everything that you're looking for in relation to the issues before the court. Now, if you are the defendant, you may want to file your own motion to be heard at that hearing if there's other issues that you want to make sure that the court hears. Because if you don't do that, just like I said earlier, the judge won't hear them. They'll just say, this issue isn't before me, and then you've wasted some time, some very precious time during your hearing arguing about something a judge just isn't going to do. So once you've had your opportunity, the judge may allow both sides to make kind of a closing argument or a rebuttal and come back and say what they think in regards to what they just heard the other person say. At some point, the judge is going to cut you off. They're not going to let that back and forth continue for too far. But if everybody's making new and reasonable arguments, the judge is likely to allow those to move forward. Once that's over, and this is another reason why settling your case is usually better, you don't get an order from the court right then and there. And this is something that I don't think many people understand. They finish their arguments and then the judge says, "Thank you, I'll take it under advisement." And basically what that means is they're going to go back, they're going to look at the pleadings, they're going to recall the arguments made, and then they're going to issue their order. Now, you might not get that order for a week, 2 weeks. There's been some cases where it's taken months or potentially longer in order to get that judgment or that order from the court. And that can be very difficult because in the meantime, while you're waiting for it, you don't have an answer. And so you do continue to have that conflict. So if it's something that you can't wait for and you can settle, I really do recommend you to try as hard as you can to reach those negotiations. But if you have to go in front of the court, please do remember you're going to have to be patient for that order. Now, that order should come to either you or your attorney in the mail. And once you get that order, that's an order of the court. So both parties, regardless of whether you agree or not, both parties need to follow that order until there's either another order, a judgment, or the two of you have come to some sort of stipulation that gets entered into the court as a further temporary order to replace the prior order. So one thing to kind of keep in mind is when you go in for your hearing, there's going to be a lot of waiting around. It's a very long day, and there's been times where it's actually taken all day. And I can think of 1 or 2 cases where we've actually had to come back the next day because we weren't able to get in front of the court. So it can be a very long day of waiting. And even though, especially if you have an attorney, you're not necessarily doing anything, there's so many emotions that go on, and it's absolutely exhausting. So if you're going in for a motion for temporary orders, it's really important to make sure that you don't plan too much for later on in the day. I'd recommend taking the full day off of work so that way you don't have that stress of having to get back to your job, hanging over your head while you're dealing with some fairly important issues. And that way, you can just relax at night. You're probably going to feel a lot of different things, at the end of the night. You're going to feel relief that it's over. You're probably going to be afraid, especially if you don't have that order yet. There might be feelings of anger and resentment when you actually see your ex in court. There could even be, happiness that you're actually taking the next step forward. There's so many different emotions, and it's normal to feel a range of them. I remember within my divorce going home, I'd feel everything from ecstatic to then I'd be crying, and I felt extremely bipolar because I didn't understand what was going on. If when you get your order, you don't agree with it, or you and your attorney go through it and you see something that maybe the judge did legally wrong, definitely talk to your attorney about what recourse you'd have. But typically, You don't get to change a temporary order that's been issued because it's during the pendency of litigation. So if you have any questions, feel free to reach out to our firm. We do divorce and custody pretty much all the time. So whatever case you might have, if you need either education or you need representation, or maybe you need some coaching, in order to do it on your own, just give us a call. We're more than happy to talk to you and see what you need. So again, I'm Heather O'Connor from O'Connor Family Law. Hope you have a great day.